Hi, everyone. We're here to talk about mediation preparation and updates in mediation case law. And before we get started, I'll let the other panelists introduce themselves.
I'm Fran Brochstein. I currently live in Marble Falls. I am the current president of the Texas Association of Mediators. I've been mediating over 20 years.
Hi, I'm Deborah Lawson. I am an attorney and mediator in Houston, Texas, and I focus my practice on the legitimate law community. So, mediation is a huge deal for us, and I'm excited to be here.
Thanks. And I'm Jill Arntz. I'm an attorney also in Houston, Texas. I do mediations and arbitrations, primarily in the area of family law and estates and small businesses. So one of the things that we've been working on and what our help sheet references is a discussion of recent case law regarding issues with mediation. And specifically, Fran, you've come across some case laws with regard to mediators signing their settlement agreement, the MSA. So can you talk to us about that a little bit?
Yes, there was a recent case, Daniel v. Morris, and I no longer sign my mediated settlement agreements because the mediator, I believe, was sued for about $500,000. He did win, but the problem is he had to deal with this for several years. And so I just use my own letterhead so everybody knows who it is. But I quit signing it, especially after that case came down this year.
So you put the mediated settlement agreement on your letterhead and have the parties and their attorneys sign it only.
Yes.
Deborah, is that a practice that you follow as well?
So, I actually had not thought about the mediator signing it much before before this little group started talking. But I love the idea of putting it on letterhead because I do think that makes it look a little bit more official. And I have recently joined the modern era of having everybody sign it electronically, so it kind of makes more sense for the other four the attorneys and the parties to sign it, and they just know I'm the awesome mediator.
And you are. I've done the same thing, following our discussion and reading the case law and just hearing anecdotal evidence of what other mediators are doing and some of the experiences they've had. I've started putting mine on my letterhead, and I don't sign it anymore either. I have the parties initial the corner of each page so that they know how many there are. And then, of course, the attorneys and the parties sign the last page. So I think that's good advice. Deborah, you recently had an experience with some Harris County courts rejecting MSAs. Talk to us about that.
Yeah. Yeah, so we hear all the horror stories about courts in different areas of Texas and how we don't have a standardized way of doing things. I'm sure everybody's had their frustrations with that through the courts. And I was recently in a mediated settlement agreement where a mediation, that's the word for it, where I was the attorney and I had a great mediator on that case. And when we got ready to do the paperwork, he says, "Oh, and I don't know what court you're in, so I've just added this Exhibit A because some of the courts are rejecting MSAs that do not exactly match the orders, or they're rejecting the orders that don't exactly match the MSA." And I thought that was a really strange statement until I read Exhibit A. But Exhibit A contained things like that the marriage is dissolved on the grounds of insupportability, that the information regarding the parties that's required by the code would be provided, that someone wanted a name change. It was these very, like, we don't even think about those things because they're so much a part of the basic template. But evidently there's judges, at least here in Harris County, that if you don't have those things in your MSA, then your MSA does not conform to your order. And so they won't sign an order that includes a name change, for example. And I just thought that was crazy. So I have adopted this Exhibit A into my template to be like, let's hit every single specific thing that the judges might be looking for and make sure the clients understand that. And I know Fran had some other things on that, like specific.
Oh, yeah. Well, I have added over the years, I have a whole page of like, I'm mentally competent to sign a contract. I'm not on drugs and alcohol. I'm voluntarily signing. The mediator did not give legal advice and did not force, coerce, or intimidate me. And it seems like every year, and that I actually read it And also because of Harris County, I add that I can read and speak English, and I did not need a foreign language interpreter. And so I've added things over the years. Now, for example, I used to do the family practice manual. The final decree will be the wording for the Texas Family Practice Manual. I've now added text docs because that's become so popular. So again, I really encourage attorneys to spend more time reading the proposed mediated settlement agreement before signing it. Or if you have some specific language you want, send it to the mediator. I'll plug it in my MSA or attach it as Exhibit A, because I think a lot of attorneys rush way too much and want it signed, and they're not being specific enough. I mean, a lot of the cases that are coming down, there's this term, I'm loving it, ambiguity. And if there's an ambiguity, they're not setting aside the entire MSA. They will send the appellate court, the Texas Supreme Court will send it back for just that one little issue. But again, ambiguity is happening a lot. I know it's happened in a ton of my mediations. So I encourage attorneys to spend extra time and even ahead of time work on the wording that they want in the MSA, so there are no ambiguities.
Well, that's something that we talked about, in several of our conferences, is just what attorneys can do to plan ahead for mediation, particularly in working with their clients, so that when the time comes, we can avoid those ambiguities, help them understand what we're talking about, maybe look at your petition, say, these are the things that we're asking the court for, and these are the things that we're going to talk about in mediation. If the children are involved, talk about conservatorship and what that means, talk about rights and duties, show them what the rights and duties are so that they can think that through during mediation, and we can fine tune it as we need to, which is what mediation is for, so that we can avoid some of those ambiguities later. Some of the things that I do too, most of my mediations are done by Zoom anymore. I've had very few in-person mediations. And because we're not all sitting in the same room, you can't print out the document or even have, one of the rights and duties with the checklist that a lot of mediators use. So I share my screen in both of the breakout rooms, or if we're in one, and we literally go through it line by line. Even the tedious boilerplate language, we go through it line by line, and we, massage the language until everybody's happy. But if the parties aren't aware of what that language means, then we spend time doing that, and they don't know to massage it. They don't know to work out ambiguities. And so having that conference with them beforehand to anticipate what those questions might be and what the fine tuning might need can help avoid some of those ambiguities as well. Deborah, what about you?
So, one of the things that I highly recommend, and I don't know a whole lot of people who do this because they think I'm crazy, but I like to actually create the final decree before we go to mediation. And I will create it, go over it with my client, fill in everything that's been discussed before the mediation, and then share it with opposing counsel, and send it to the mediator to say, hey, I would really like this to be the basis of our discussion, because we can, if we agree to stuff and both clients have seen it, we can take that off the table and we don't have to waste time on it. And one of the things that I think I'm frustrated with, and so I was really excited to be on this panel with people who had ideas about it, is, that it's traditional to have a 4-hour and 8-hour mediation and think that you're going to accomplish everything, even in a 20-year divorce with 6 kids. And so I was very encouraged by you guys saying that you're trying to slow down the mediations, you're trying to encourage the attorneys to take some time. I recently had a case where, because it's been going on for like 3 years, I realized that something we discussed very early on in mediation never made it into the MSA. It therefore never made it into the final order. But the 2 clients have been abiding by it. It's the one thing they've been abiding by because they all think it's in there. And so, but that's kind of the exception, not the rule. And I don't want to kick it back to you guys too, because talking about this made me think of something y'all said that I never thought about and I'm terrified of. And this is the confidentiality question. So after we've just gone through this 50-page document and said everything's confidential in mediation, well, it's really not. So I'm going to throw that back at y'all.
Well, again, the Daniel V. Morris case addresses that. And I now have in my agreement to mediate and in the final decree of divorce that the parties understand that mediation is confidential. However, if they sign the mediated settlement agreement, that they want it filed at the courthouse, and they are aware that it will then become a public document. And I am trying not, whenever possible, I try not to do any of the e-filing, because then it didn't come from me. But sometimes I do a lot of pro se's where there aren't any attorneys. And again, when I do those people, I only do 2-hour sessions. And if we go past 2 hours, usually we're going to settle. But I go very slow with them. And I also refer them to this fabulous website, texaslawhelp.org. It is fabulous. And I believe if you have a divorce in Texas, that you should look at that, because not only do they have free forms that they can at least see what it's supposed to kind of look like, but also they have it written in very easy to understand language. And again, attorneys don't have time to hold their clients' hands. So there's so many YouTube videos now by Texas lawyers that there's no excuse for people walking into mediation and not being aware what mediation is, and two, what the laws are in Texas. There's so many free resources. They don't have to pay any money to get all this free information.
So do you recommend that lawyers in preparation for mediation tell their clients, hey, go look at this website because it will answer a lot of your questions. It'll show you what the forms are going to look like either during mediation or after mediation, you know, what the final decree is going to look like and the issues that we're going to have to talk about.
Absolutely, because quite frankly, a final decree of divorce in Texas now, especially with children, is scary long. I mean, it is. I volunteer at Lawyers in the Library here in Marble Falls, and people show up, and I mean, they're not a standard divorce form that I've ever seen after being a lawyer 33 years. You know, when people say I have a standard divorce, I'm like, I have no idea what that means, because I actually just saw one recently where the father had no, you know, that long list of the 24/7 rights both parents have. He had 0. And I said, this is the worst decree I've ever seen.
Was it someone just copied and pasted and just forgot to copy and paste that document, or was that, or that portion of
it was done on
decree?
purpose? It was, the other side had an attorney, and they just basically, the guy, his visitation is whenever grandma wants to let him see the kid.
Wow.
Oh, it's a horrible decree. I mean, I told him, I said, and he's got a good job. He's a nice young man. He's stable. And I said, on your worst day, you probably should have custody now. But if you don't get custody, get this thing fixed. Because I mean, it is, they gutted him because he didn't have an attorney and he was young and stupid. I think the kid's like 6 or 7.
Well, and that goes back to ambiguity. That a provision like that wouldn't really be enforceable.
It was hard. Right. It was a horrible decree. So
something you mentioned, Fran, is something that we've also talked about and that I see in other states, and that is not having this marathon, or it's not a marathon, this hyper-focused 4-hour mediation that, you know, it's hard for parties to process it all and negotiate and make decisions in this emotional, very life-changing event that's been going on for who knows, like you said, you had a 20-year marriage with 6 kids in 4 hours. So one of the things that I know other states are doing, and it sounds like maybe you might be doing as well, is coming in for shorter periods of time and maybe resolving some issues, then going and coming back. Is that something that either or both of you are doing, and how successful is that?
Well, with the pro se's, I don't give them a choice, and then I will send them a draft of the mediated settlement agreement so they at least can begin to see it. I mean, and a lot of them, where we start off and where we end up, completely different. And I listen, I love mediation because I can address things judges would never just deal with. And I had one lady that was pro se. The other side had an attorney. She hit the wall. And I think I told you ladies that I told her to go outside, take 10 deep breaths, get a glass of water, no alcohol, and that we would rejoin in 10 minutes. She came back. We got the whole thing done. She said, "You're right. I just needed a break." And she just had to go out and take some deep breaths and just calm down for a few minutes. And I was able to settle the whole, because she just she got that deer in the headlight look where it was just hitting her too hard. So again, I try to really listen to the people. I had one attorney say, "We're going to settle this case today." And I said, "Well, you need to look at your client, because your client is like this going." I said, "I don't think we're settling today." So, but I've settled cases that okay, the impossible I can settle. It's the ones where there's one issue. Those are the hard, and I couldn't even settle one with regarding a dog. Those are horrible cases.
Yeah. It's like trying to balance your checkbook when you're off by a penny. I agree 100%. And I agree. It took a really awful case for me to realize we had a marathon mediation. It was supposed to be 4 hours. It turned into 8 hours. It turned into 12 hours, and it was literally like 11:58 p.m. And I took a bathroom break, and I realized I was committing malpractice because I could no longer think straight. And here I was trying to encourage my client to settle a case, and we finally did. We at that point I had to call it because I realized I couldn't even remember my client's name at that point. And so we came back, maybe a week later, and it was exactly like Fran said. There were some issues that we were so far apart on, and all of a sudden a week later we were like, wait, we don't care about that. Yeah, that's fine, whatever. So I think that fear that a lot of us have of if we don't hold our clients' feet to the fire and we don't get this done today, then they're going to change their mind. Maybe that's not always a bad thing. So I am very much in favor of the shorter, several shorter mediations, and just trying to get things off the table one at a time, rather than trying to be like, well, we threw it all at the wall and we hope it was really good, because generally I'll miss something at that point, and then I'm just mad at myself forever after that.
The people shouldn't be afraid to take a break, whether it be a short one for, to take a deep breath, or maybe call it for the day and say, look, we just need to reconvene so that nobody makes a mistake, and the lawyers are not making mistakes, which could set them up for a problem later.
Yeah.
But lawyers have become so ingrained, whether it's like you said, trying to just, whether it's them thinking that if we leave, we'll never get it done, or that's just the way we do it in Texas, right? They've become so ingrained to, we have 4 hours, we're going to get this done in 4 hours or 8 hours or whatever it may be. And I've had some marathon ones like you as well. We went till 2:00 in the morning on one of them. We were all still still very much engaged in the negotiation, which is why we continued. But it's probably not healthy for any of us at that time.
Yeah.
But yeah, I think that people need to remember, look, it's okay to take a break. And like you raise a good point. If you take a break and you come back a day or two later and say, this isn't going to work, that's probably a good thing, because it avoids, if not litigation, at least, the parties not getting along or resenting each other or creating animosity within the family that otherwise wouldn't be there if you would just take a break and say, let's just regroup, right?
And I can't tell you how many times I've declared an impasse, and within a week, the attorneys call me and go, we settled everything. And we did it exactly, it was exactly what you said. They just had to go home and sleep on it and think about it.
And maybe understand it. It's a language that we as lawyers and mediators and arbitrators, it's a language that we speak, but it is a foreign language in some regards to many people. They don't understand our acronyms. They don't understand what, the legal terms are. And so sometimes they might need to just understand, okay, I'm scared of this. I'm scared of this word. I'm scared of what it means. But if I can sleep on it and understand it, I'll be okay with it.
And to that point, I want to bring up, there was a case I was mediating where it was actually the attorney who was concerned with what the resolution, what we got to was, and I think he thought that we were trying to pull a fast one on him. And it was the attorney who needed to go home, be able to consult with a supervisor or with a longer practicing. It was a very young attorney. And you could tell he didn't want to be mean to me as the mediator and be like, I think you're BSing me. But I could definitely tell we were not connecting. He just didn't have enough knowledge of the law that to me was like, dude, this is like the alphabet. What's the problem? Uh, and so I think sometimes everybody needs to be able to step back, Google something, look it up in the code, and get comfortable with, I'm really not trying to snooker you into something. I have no dog in this fight. Uh, and I think sometimes, and I fall for that sometimes too, because I'm like, why is the mediator on their side?
Point as mediators, I think we can see, we're new to the case, so we don't have the predisposed ideas or solutions or animosities that the parties and the counsel, bring to the mediation. So I think my experience is pretty early on, I can figure out where a case needs to go and what it's going to look like in the end. Not all the nuances and things like that, but you can pretty well figure it out. And you're not on anybody's side or advocating for anybody's side, but you can see the strengths and weaknesses of each case.
Yes, definitely.
So, Fran, you are along the lines of keeping up with these current cases and with your experience in mediations and involvement in in associations. What do you recommend for mediators and even attorneys as they go through, mediating cases?
The field of mediation is changing. It has changed dramatically in the past 20 years. And as an attorney, you have to take annual CLE. Well, as a mediator, I take at least 15 hours every year. And especially now, there's been, at least in the past 2 years, at least 12 cases in appellate court, may go up to Supreme Court. They haven't come down, they're not finished yet. But people are going after mediators, and I would not mediate unless I had malpractice coverage. And I also encourage people to consider joining some groups or a group or groups to keep ahead. So the groups that I recommend, of course, is the State Bar of Texas ADR section. They have an annual seminar every January. And then there is the Association of Attorney Mediators. They have 2 seminars a year. And with your membership, you get mediation malpractice coverage. And then there is the Texas Mediator Credentialing Association. They have an annual seminar every October. And the Texas Association of Mediators has an annual seminar every March. And again, these groups also offer Zoom calls and discussions. And I really encourage people to keep abreast, because one reason I'm aware of all of these cases is because I belong to all of these groups. And it has been shocking to me how many, that more and more they're going after the mediator. And if that doesn't scare a mediator, it should. And it also should let the attorneys know that they need to keep abreast on what's happening, because people are litigating like crazy, and people are unhappy with what they settle, and then they try to figure it out. Now, the problem is that the Texas Supreme Court is standing behind mediation. And so when you sign a mediated settlement agreement, it's pretty much done like dinner. It is almost impossible to wiggle out. And a lot of people are trying different ways. And I will say they're being very creative. I give them credit on creativity on that one. But again, I learned a lot just in the last year by attending some CLE for mediators and finding out about all these cases. I had no idea about all of this stuff going on. So please keep up to date and recognize, if you're a professional, and I consider mediation to be a professional field, you need to keep up. Your hairdresser and your massage therapist has to do annual training. Well, so should a mediator.
Well, and a lot of us who mediate are on our own, right? We're essentially solo practitioners without, the connection and locker room or lunchroom talk that you would have if you were practicing law in a firm and, discussing recent cases and things like that. So it gives you kind of that camaraderie and that keeping your hands in the pot, so to speak, so that you can keep abreast of all of that. And I know one thing that we talked about was having a mediator study group, like there are probate study groups and, family law study groups, just so that once a month we can touch base and say, have you had anything recent happen? What's going on? What have you heard? What are, some anecdotal things that we might need to consider? And I've completely revised my mediated settlement agreement, form after our conversations and some of the things that we've talked about and the case that we've reviewed. It's really helpful to stay engaged like that, more than just attending a CLE, which is absolutely what you should do, but it's also nice to have that camaraderie and those resources.
Absolutely.
Anything else that we want to add and tell our listeners before we wrap up here? It looks like we have about 3 minutes.
There's some Facebook attorney mediator groups.
Yeah,
and that, again, that's free. And I didn't mention it, but I'm also on the board of the Tarrant County Association of Mediators. They meet every month for about an hour, hour and a half, and people just bring their questions. And I actually had a very strange mediation I brought, and we discussed it for an hour. And other times, if nobody shows up, we just sit around and talk about the weather. So again, you don't even have to join that group. That's free to show up once a month. And TAM, as a Texas Association of Mediators, has really been reaching out, doing more and more to help the field of mediation. We do a monthly TAM talk, which is, if you're a member of TAM, they're recorded. We're in our 5th year, and we're also doing quarterly question and answers. And then Lydia Miller on Facebook has a monthly meeting for new mediators. She is about an hour, hour and a half once a month, and they get together via Zoom, and she just takes questions from whoever shows up.
Are there other association of mediators like Tarrant County has in any other counties across the state? Do you know?
Not really. That's the only one I'm aware of.
Okay.
And I don't even live. I never have mediated in Tarrant County. I just know a bunch of the people up there, and so now they got me on the board because they do it via Zoom. So right. It's fun, and it's fun. It's a fun group, and I'm always learning. I mean, I always say the day I have the same mediation twice, I'm going to retire.
Well, I'm always surprised by the people who don't want to mediate because they're like, there's just no way that this case is going to settle. Because I think that you actually have a better chance of getting a better deal in mediation than in front of, a judge who's just trying to kind of get you through there and get their docket cleared. So I love that there's people that I can go to and be like, hey, this is what's happening in my case, and I'm stuck. I don't know what to do. And the mediators that I've been fortunate to work with are great at being like, well, did you think about this? I'm like, and I always laugh because they'll be like, well, why didn't you do X? I'm like, because I never thought about it. So call your friendly mediators.
Yeah, I mean, I think that's true. We're always learning all the time, and every case is different. And, that's why we do mediation, so we can have those unique settlement agreements that, like you said, you can't get in court because they're bound to the family code and they're going to do X, Y, and Z just like the family code says. So it does give the parties that opportunity, and that's what makes it interesting.
Absolutely.
Well, I have thoroughly enjoyed working with you. I've learned so much. I've made 2 new friends and 2 new colleagues in this the field of mediation, which I'm passionate about, and I really appreciate the time that you guys have put into this and spent with me.
This has been so much fun. I can't tell you.
Absolutely. I think this has been so much fun. And I think that we're going to convince Jill to start one of those study groups and invite everybody who's here with us today to come join us and just talk about your cases, because it really, really helps. And read the case law, because these cases that we're talking about, I've read them. They're crazy, and you need to be aware of them.
And they're all on the help sheet with citations and summaries. And We do. We encourage y'all to read them. Thanks so much.
Thanks. Bye.